I was your member Aquaba, a 95.1 FM, and Augusto, yeah, Utieno, Penny Fortas, Mena Catro, lawyer Kwasi Kwarteng, and a doctor Sammy Ayeh, or me and becoming some penny from Mama Quabana pay. And Pom to say, and Ramen starting free a lawyer Kwasi Kwarteng, and minority a press conference and positive defiance is what they want to do. Almost one majority at the moment. Hey. Minority. As a man, I'm confused. Me who baby, I'm Miss Ramonti, and my shepherd for NDC for a woman. One year press conference and some judges is your no advice. Vice chair to a committee. Oh, now I'm quite a court.
Yeah, with your phone now. Let me monitor because of the brand really, you know. They only say, medium say more and more parliament, one way of branding for. Majority of them are, I mean, more legal training, legal background.
So, a former Attorney General was part of those who were there.
Or more money legal training, legal background, or much of law, and they may say, a lot of them know sometimes, you know, the usual party drama says shenanigans, but beyond that, you know. In our own honest opinion, because you read them near the position of the law, Obia will have a very honest view about what the law says. Indeed,
but you are a lawyer.
Yes, indeed.
Gladly you are. The Constitution is clear. Article 97(1) G and H.
I said what I'm about. Indeed, about say and Tiasia, never when Nina, and I'm DC was say, what has I want Tiasia? Assembly by so, Anna majority. Led by Mr. Fendomark and court. Now, court, according to the substantive matter now, because out the poem, a court to say it's a witty assembly with the parties all coming on board. Important to stress a substantive matter now, because a court to go.
Debbie.
And what the court has done, just a ruling now, a injunction, just to stay the execution of, for instance, Speaker Samoy Day, or kind of determination Speaker MI. For instance, and I am here now, make do a dream now, Dr. Duchum is Kwasi Kwarteng, you as my can already was myself a day.
Coca.
Now, Dr. Duchum, so ministry car, one more, media ministry, and it be a ministry woman near dear 1.9, or security for my whole name, and fee. And Bremono said Dr. Duchum, a make his decision, said, while mammy be a friend of fair hearing under the principle of natural justice. And many muna meet to me cap of quarter catch a course on Kamas and living there, mammy. Now, court on can say, oh, my daughter do to decision I was making it or than I was any day. Unjai. Now, Ujai, we are a children, no employment no one saying because the Ayanesa, not Dr. Dutu to Aswa. The Abayane say, well, here, Baba Jacano, a may declare a few once and by any day, then can you. Because it will cause an irreparable damage to me. And in that case, you know, within the remit of the law, put him in court. No one can say, oh, court will stay execution. Execution essentially means adia na emrana na say order no mo man. He says so on perform and implement this order. Court ne dey emfata bo ne dey ento so. Ansa na yakasem no kra dey ewo ho. As to whether the merit is in or merit is not in ansa na yaka ho asem. In the context of that discussion here, so we can say penny, now your majority win your minority one point. I don't even get why that is coming in the first place. Because in the first place, the substantive matter has not even been heard. If instead of execution court to grant it, you can just go to court to even file a review. Say court to no review side decision or here or make it. In the second place, the court on assembly court is essentially saying say speaker decision or make it. Set sample now. It will be very unfair to visit the sense of those 4 MPs on their constituents. And no kaya 2013 electoral petition. Mr. Chikata made similar argument. A brand presiding officer, and I was almost sign pink sheet, so man sign MPP made a very strong argument. Say, Sadia, young council annulling those votes in. Mr. Chikata made a similar argument, which even me, na me MPP, na me nene because Mr. Chikata small kind of say Obi and sign no one responsible with his role as a presiding officer. Why should you punish voter now about 100 or 20,000 voters no more day?
But you went against it. You wanted as a party, not you.
No, at the end of the day,
you were seeking for that to be done.
At the end of the day, that was the reason why we went to court, and the court made a decision, and that should stand.
Yes.
In a similar vein, you were empemping so what are the facts? The facts are that Yako court. Yako court, the court has made a determination. Say you hold on. You hold on with the execution of
the issue is the fact that the Constitution states clear 97 G and H.
I'm a trained lawyer. First of all, before we even go into the merit of it, can't be to a friend the principle of natural justice. Principle of natural justice. As soon as you breach the principle of natural justice in the first place, we don't even go into the merit of the matter. Now, principle of natural justice, and they say, okay, Brian and Coupon de Adam, and they if you are in one mobile was so a different to us, one from us a more hay. Then I miss food among Sanka, Modern America. That was an opportunity for them to be heard. And it is a tried law and established principle in law. Say, as soon as our back you will be an answer will be a woman acquainted a 18. So what am I?
I've been your marking to them more Parliament.
Maybe make a banana. Me be a nicka and be. And so what if a corner judgment and answer and answer catches of saying why and the home and so without giving an opportunity to the person to be heard. In law, we don't even go into the merit of it. Court will be at Togo. I know your friend say a void ab initio. Before Craig best started assembly and it will be void ab initio. Now the same way they see it. So MPs fall. At no point did whether the Parliament or Speaker of Parliament even give them an opportunity to be heard. The here and say, yes, my idea be a chess mob team post into on that basis, young Chimons inside. And to share petitioner. An application of no mark in the court. It was one of the things one of his reasons, and I say the very strongest case that he made. That if you look at
Parliament in your court then.
No, but no, in the principle of natural justice, it's not about court. Ahasi, Nanaya.
Go and say. Say I'm running a special That's
what I'm saying. It's a principle of natural justice. It's an established principle in law. Nanaya now to show you know you may for the letter. Court to be anywhere but just how that to the only thing they say court to be just tomorrow no more opportunity to be heard. And what we are saying is, and there is a precedent to that. There is a case Republic versus High Court Accra ex parte Lai Mensa. Court and they say failure to grant a party an opportunity to be heard is a breach of natural justice, rendering the decision void. And to make before once I'm Article 97 before Becca was some crowd. So far as it is established as our four MPs, you have more opportunity to be heard. I avoid. Me independent be say na Esiama time na Esiama so no ya but in the case of Esiama letter the call Parliament we copied him.
Now, someone you
know. No. As soon as we copy you, it's an invitation
for you to be heard. Though you said to be heard, not notice. Okay, one can notice. No, you see, what's it to be heard? You copied him. You didn't ask him to talk or to even seek his opinion.
Letter my general manager. Now me copy one. Essentially says that it's an invitation for you also to act and to first of all peruse the letter and then act upon the letter. So there's two facts are not the same. But even granted, it's even the same. So breach of natural justice occurred in MPP. So we should also allow it to be occurred at this time. Even that is even the case.
No, it's the only thing is the fact that like at one point you are here, at another point you are jumping here. When
I said the facts are not even the same. Now we move on to question about interpretation. First of all, Ghana Chrome High one, you participate be a friend. Constitutional supremacy. What kind Article 2:1, even Article 1:2 of our Constitution is very clear and quickly say menya kwenya kan. Or say Article 1, say the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government had to be exercised in the manner and within the limits laid down in this Constitution. Okwa 93 mpokura na editumi ma Parliament say Parliament go about the procedures one shemrani ad or say 93 subsection it was subject to the provisions of this Constitution. The legislative power of Ghana shall be vested in Parliament and shall be exercised in accordance with this Constitution. And in Ghana, unlike UK, in UK, one participate be a friend of parliamentary supremacy. The one of Parliament customer a move to pop asa. In Ghana, your Parliament the customer.
But there was a case in the pen. I'm a producer. Me say JH Mensah versus Attorney General on the same issues like this.
Yes.
That Parliament and the court declared say Parliament can say we are asa.
That is when it relates to the procedures of Parliament. What I say?
That's the way so procedure.
No, Article 93 it has nothing to do with the standing orders of the Parliament. Article 93 no, a constitutional provision. Yes, your procedures of Parliament. Procedures of Parliament say, oh, Parliament better twice in a week. Parliament better no pass 6. Parliament be close to 8. Majority better, minority better, and no Supreme Court.
Over 2 seats, 15 days, and no, your constitution.
No, that is that.
Your constitution.
No, Article 110. I mean, so I think there is a provision in Article 110. When a Parliament in Yani to me to be able to do its all procedures. 110, subject to the provision of this constitution, Parliament may by standing orders regulate its own procedure. The constitution, Parliament is Onua can regulate its own procedure. In that particular instance, the procedure, Supreme Court cannot make a determination for Parliament on how its own procedures are run. What I say, but in case of say you was standing on the B and an application of the constitution. And that application or interpretation of that constitution, it becomes inconsistent with any provision of this constitution. To the extent of that inconsistency, shall be declared void. And until Parliament, Article 130 of the Constitution, which says, when it comes to interpretation and enforcement of the Constitution, it is the work of the Supreme Court and not any other arm of government. What Mr. Babin sought to do was more or less engage in an act of interpretation. And act of interpretation based on Article 130.
As in what? Act of interpretation saying the Constitution was clear. 97
1
G and H. Shall WOHO.
We 2 simple questions per person.
Be 97 G and H.
Article 97.
G and
a
H.
member of Parliament shall vacate his seat in Parliament. Of course, it lists a lot of instances of
G and H.
The G and H, And first of all, I'm mindful of also assuming the rule
of the Supreme Court.
Yes, of the Supreme Court. Okay. If he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member, whichever way, the TBR. I don't know.
That's one kind
it doesn't support your case. No, but how did you understand this? If he was elected a member of Parliament as independent candidate and joins a political party. What has I said?
As a case, I'm an independent candidate in Parliament.
Granted, without even admitting same, say this amounts to cost capital. It is not left to the Speaker of Parliament to interpret this and then make a declaration in Parliament. That is the sole reason of the Supreme Court. Granted, says which is that's what this means. You don't interpret the Constitution based on a future intention. What I say? Obi future intention.
It's not future. We declared that. We're filing to become an MPP parliamentary candidate.
I was trying to run away from this because that's not my work.
Okay.
In Supreme Court, I was trying to run away from. But as I say, consistently, we cannot go into the merit of. But even if we want to go into the merit of it, because I'm taking a positive approach of interpretation, for instance, let me give you a law like PNDC law 111. And Caneno. Na awari mu no sebi ebu na beja pade ani ade a to matrilineal inheritance of anomone nyakoje yes in the purpose of salon even though the nomenclature you see as spouse obi a or interpret salon bia as a justice of the court no will be more biased towards because the intent of the framers of the law was to protect women and cure a certain mischief. If you look at how this mischief was to be cured, where is the history? The history is about Parliament, over Parliament, and then you attempt to cross carpet. In this case, so what is most crucial has to do with the timing of the cross carpeting. The timing. Can you hold them liable for cross carpeting? And I'm saying that we should not even be having that discussion. There is a more discussion for us to do. And and it is even the more reason why we call it that there has been an ambiguity when it comes to the provision of this very constitution in relation to Article 97, 1G and 8. And as soon as there is an ambiguity, speaker here.
So at the moment, where we stand, though, the Supreme Court could have actually sat on the case and then decided on it. Interpreted this particular
Supreme Court, the Supreme Court, their own procedures, just like if we go to.
But is it not strange that the person asked for 10 days? And Supreme Court decides.
No, it's not strange.
Your application was 10 days. Then
No.
Supreme Court decides indefinite.
No, it's not strange. It's not strange. It's supported in law. First of all, the Supreme Court has inherent power to grant such any order. Or was that to me, Now, if you can say ex parte application, and can you say Supreme Court a grant? Now, but granted plan now. I say any can say more than 10 days. Order 25 of CI 47. Very clear. Some part. Ex parte application before Supreme Court never granted. Maybe on emergency situation because ex parte chair say, "Nana ya me no wasema, maamu amane say I didn't put notice. Say, kame me no wasema. Be fans watch masase. Watch masase no kame do court case. So go mama na ka also be the over present. By your situation, mrano chair say when one day wa mo ni papa man. Especially nipa who say so when you through me can court to pay. There will be irreparable damage and so those are situations where ex parte applications come in. But the argument is ex parte application the court no be just to plan emergency circumstances. Any can say ruling in that court in terms of stay of execution or indictment shouldn't be more than 10 days. That's order 25 for CI 47. Me no mo judge. But if you order 25 for CI 47, there is also a case law. Rosemary Kwando. The case at court no say but what say in appropriate circumstances, a court of law can grant a relief not sought for by a party. And the court no what to me say.
Onua.
Yes.
Yeah, the old beba no be jina why.
The obeti kra mabrosa. Was my kind of the only
case some court for any lawyer for any mo confuse you.
Oh, debut. No, that make say, who say mrasem no utumra no ayede.
What you say?
You can't just leave it hanging. So that you state the authority and people also refers to the authority. There's a case of Rosemary Kwando. Rosemary Kwando case. Court on say, so do assemble. Now so any person so no assemble. Na if I say car, ni person dey waka be 2 million. Now the union say mo no, o dey assemble buy no. Ebia, I will say, we see ni panama 100,000. Court union say when they see
it, 500,000.
You can say more. There's a case to that. The court never heard. Particularly when it's within the interest of justice. Assembly can say beyond politics or any beyond law. Nanaya, Yemfano in a reasonable man's approach. Reasonable man's approach. 3 months to elections. Why would any reasonable person take this initiative?
I said 2020, not reasonable. Don't wait to answer now.
The facts are not the same.
And the reasonability.
No, the facts are not the same. The timing is very crucial.
But at the same time, it was 13th October. When John Boedu wrote the letter to Parliament.
13th October, yeah.
2020, 13th October.
That's what I'm saying. That in our case,
the same timing.
No, you see, in our case, we respected the principle of natural justice.
So, I want to person bisa one question. Say, is there anything called ignorance of the law has no excuse? Is there anything like that?
Yeah, the law is clear. The first say we name, the second thing say we name.
So, at what point is it being applied?
It's a maxim of law. I think you have to ask your question holistically. Let me who the
yeah, because the person who at what point
say foundation but
yes, and it say okay say fair hearing na na say bia unim mra na say unim mra no mpo na say still na akokoya. Where lies the fair hearing?
So fair hearing is the most important principle in law. It doesn't matter whether you know or not. As soon as fan say what will be say why are there before obeti mama any judgment on it, I will say utini pakro. That's why I started free, even the biblical perspective of Adam and Eve and God. And the area see baby it's not only an established principle in Ghana. That's why I'm really say okay decision court will make here when it comes to even the case of
he doesn't dispute that fact. So I think he's just getting a bit of the fact that he feels that ignorance of the law but in this case, the fair hearing and the ignorance of the law,
no, they are not the same.
They are two different things.
They are two different things. So I wanted to get the connection.
Okay, that's fine. That's fine.
Right.
What the mission now?
What the big kaho? My 2 minutes.
Yes. A bill also no. One more can say, oh, Parliament go by its own procedures, and Parliament will do its own making decisions and whatever. It's true. Parliament particularly when it comes to the procedures. And it's I'm referring to Article 110. The Constitution now Parliament need to make their own laws and other things. But you see, from her, say Parliament to says Supreme Court to say executive for all laws, because we are practicing constitutional supremacy, all laws have to be consistent with the provision of the Constitution.
Yeah, but then NDC caucus, I say they respond to the speaker. Yeah, but Kwarteng, me person doctor, me person Supreme Court, me benya case you nti mama nyina fifi.
Majority because they say on paper, Supreme Court are making decision. I say
majority minority. In fact, more amasem. NDC caucus at the moment are stating that they work with speaker, not Chief Justice or the 5 Supreme Court judges. They are going to Parliament as majority. That's it. That's all they know.
Per the extension of their logic, Electoral Commission, they don't work with Electoral Commission. When Electoral Commission makes a determination on the outcome of the election, they should reject it even when it favors them. Per the extension of their logic, when the police make a determination on anything, particularly when it comes to the enforcement of security and safety, they should not respect it. You need banana republic. In this bad power, Supreme Court cases MPP has lost as against NDC. We have lost more than them. What are they talking about? When the person can say there is a Supreme Court, you know, a bit bias always. And I'm saying that we've lost more cases than them. MPP has lost more cases in the Supreme Court. Recently, Papa Attorney General, a case a former military officer, recently case here Attorney General, we lost it at the same time. Oh, mirror free case. I'm sure you remember. It was a popular case.
Yeah.
Papa did be a some nickname. Now the better can. But medicine. Parliament, open Justice Kolendi. In the case of Justice Abdullahi and Attorney General, there is Abdullahi case na Deputy Speaker, where they say Deputy Speaker, be Speaker, and when they won't proceed. This is the decision of the court. The same decision was stated in Francis Osei and Attorney General. Court and they say, even though Parliament is a master of its procedure, the court need to say about procedure. They are there. We are master. It cannot be overemphasized that all the rules, orders, procedures, and practices also have a master. What is the 1992 Constitution? And you cannot hide under the umbrella. Say, because of separation of powers, what the WOHO. Now you can just apply your procedures and make your procedures required. The Supreme Court even doesn't have any point any to it. But for instance, when it's misapplied and it goes contrary against the rule of law, and also command orders here, now those orders are not consistent with any provision of this Constitution. We have to go to the Supreme Court based on Article 2 and Article 130 to go and seek an interpretation. And I'm saying, Semidisi, the work of the Speaker is administrative and procedural and not interpretative.
But that's it. Doctor. Yeah, quite.
And I am a das.
Odo kweti.
Well, I also go
main chairman, me opinion Kwasi Kwarteng poem crime me businesses my okay. Me senior brother Kwasi Kwarteng say Supreme Court na interpretation and I'm aware.
Yes. When there's ambiguity in the law or there's confusion.
2020 time omo party no throw letter come as speaker. I don't know man trauma and come as Supreme Court. Now Supreme Court man amber declare those seats vacant. Please, work at please. Please, work at say. Please. Oh, please. What's the party? Nana, question I maybe sana. Is it a legitimate question? Yes. MPP for your muhu nyansabo akwa. Oma your muhu diablo ni. Oma your muhu tisa anoma na omukwa na nso ano ekobru nso nani anoma yedai. Oma ba na afo abisu say nso nani ayedai. Asay.
Na ndumi nso so on the also person so.
You understand the point I'm making? Article 97 1G and H is clear. Me as a medical doctor cram in see law class cradam. Me kanya metiasie. Oti way. Questions I will be sa Kwasi Kwarteng na because what kind of constitution? It is clear. Or say 1. A member of parliament shall vacate his seat if he leaves the party of which he was a member at the time of his election to parliament to join another party, or he seeks to remain in parliament as an independent candidate. Okay, H no say if he was elected a member of parliament as an independent candidate and joins a political party, it is clear. And Tikawai and Kembe declares his vacant. This year, Womi Krum, and our assemblyman or area. Now, seats no, I will court, and I will Flagstaff. Is it not in parliament? Who should declare the seats vacant? Nanaya, Asma make what you say.
Another case in sight. As we speak, there's a case in court. Now, the case in court has to do with LGBTQ. The same interpretation, yeah. In fact, it's about the fact that transmission. The law states clear in the Constitution on natural canal knowledge. And it's clear on natural. Meaning, bema now yes or apart from the natural way. The can now you're natural. But as we speak, as we speak, Parliament at Nasi Asan in that like to be because they felt that that law is conspicuous. Like I say, Emrano, I be your share now. And here be a way so confusing.
And no crowd about could be almost a patron of
Then see a parliament for the first time they are intending to stand up.
And no cry section 104 1B Act 29 of the criminalizes on natural canal knowledge.
Yes, ye jaw na one can once a Nanaya. Now let's go to the matter. She, there is separation of powers. In fact, okay, there is a case of 2-4 versus I think government of
Attorney General.
2-4 versus Attorney General.
Yes.
The Supreme Court was clear. Say a constitutional body to say parliament cannot be interfered when it comes to their work. Now, Article 110, which spells out the framework of parliament in terms of master of their own rules, gives parliament, especially the speaker, that authority in that regard. In fact, Article 18 cry, say if anybody cry intends to serve a member of parliament, any official of the parliament, even the speaker, permission must be granted from the speaker of parliament. Is that not it?
If parliament is in session.
Yes.
In session.
Until I was speaker cry.
If not in session.
I was speaker throw letter cry, comma court cry for his permission. Is that not it? In fact, okay, Article 22, it goes on to say, Obibia obey impediment, obey stumbling block to a process of parliament, to a member of parliament or attending parliamentary functions. Obibia obey the person is in contempt of court of parliament. Menoka says Supreme Court is in contempt of parliament.
That's why
it is affecting parliamentary proceedings. Yes, say constitution.
It is not parliamentary bylaws.
May read the constitution actually. The constitution is clear. Article 1 to 2. It is clear. Or say an act or omission which obstructs or impedes in parliament in the performance of its functions, or which obstructs or impedes a member or officer of parliament in the discharge of his duties, or affronts the dignity of parliament, or which tends either directly or indirectly to produce the results, is in contempt of parliament. And the Supreme Court is in contempt of parliament. Nana, out to the mechanism. Nadentia amount for baby. In fact, the precedent being set by the Supreme Court, it is dangerous for the people of Ghana. Idea a bit midi oyene kesia pa about Ghana. Nana ya odim detia. She Ghana. Adie ba ko Ghana for omakuma dasu. Ghana for bebre esu ho. Ghana for bebre oma chere adwen. Ghana for bebre a chere se omani nje ho. LGBTQ. Nana ya so dem ya adwen.
Yes.
Me no ka say imams asofo akukudam traditional leaders
all of them have
obia sadie omumpe for the first time in the history
and
of Ghana.
And it's in our constitution. And you me can say what so I am bravo.
Mama to me esa. Oma pekete akogina Ghana street to say ade yempe akodi Supreme Court nsem. Supreme Court yesremu. This is a matter of public interest. Montra so na yehu ba bi egina. Supreme Court di nuagu wo maso. Said your monte ye. Imam so asofo akukudam omantimi mpo ampreke
to be
the
fair,
attention
Chief Justice after they went picketing brought a release that they are waiting for the Omo case by to
now when I say Omo case by they have not been following up. One is speaker one is speaker lawyers on court. Do you know the number of times on my court? But nipa ba akopeu
they've not filed the application.
Nipa bebrebe we nyina ntimi a preke the attention o man ntimi akwote the attention of the Chief Justice and the Supreme Court. But nipa ba akope afenyo market. One day, in fact, I'm saying this on authority and I will tell you. The judges were in their houses.
Oh really?
Oh, you don't know. You are
me say. One of the judges no fear wada ewia wada.
How do you know this? Are you
Otifia near friend of phone so say Chief Justice say asem about anopa 9 o'clock and asem ne ekoye 12 na your friend judge odi mika ne namu mika
now ho
every fear akokot say yes say minority leader the asem bia ba Mr. o minti me money minority leader the asem ba enti yem betena so
when minority leader
ai eya afenyo market or the assembly aba enti omomra metena so nipa ba akopeu etimi ahole the whole Supreme Court 5 judges e de omakotena say but imams akase akukudam Ghana for over 30 million na omoso omompe LGBT no ene omutifie omasem yenkan yes o ye Supreme Court o ye court e wo sa wo sekan no e ye double edge sekan no for no atwa ha eba cases be there hurriedly na Supreme Court atenase but eba cases be 2 years e-levy and a minority case on the court about e-levy 2 years Supreme Court NBA docket in the mumbo but afenyo marking any MPP 4 case there in less than 3 hours yatenaso na de ba ko a metia but said they have heard it Oma shall say Oma grant an injunction to halt a constitutionally mandated body from discharging its functions. And it is dangerous. One of the reasons that Supreme Court might say this move, the NTO granting injunction say it will obstruct the business of governments. Now Supreme Court today, government business of our home. So if there is any, obviously the mischief. And it will halt government Supreme Court government business for home government policies any e-levy any betting tax minority say be here for no if Supreme Court home how
hey
if Supreme Court
see why MFE and
the Supreme Court is now entering into politics.
Why would you say so?
Yes,
it has something. It has a national security implication.
Please.
It does have.
Please, it doesn't.
Really?
Supreme Court looks at the law. In this case, they are looking at the politics of the matter rather than the law. And I think that it is dangerous for Ghana. Now, Matisa MPP for ne Nkofobika say fair hearing amber. Now, time our parliament convening no, did they prevent any member of parliament from coming? Now I am a question. Yeah, the letter
the speaker almost prevented the then majority leader from speaking.
Did he prevent the 4 affected members of parliament from speaking? Were they even there? If yes, a parliament is here, the speaker have to hold a cane chasing every member of parliament. Parliament to no, parliament is convening, and so that matter of fair hearing, no, it is neither here nor there. It does not even make sense. What's the make I say? ATM before the in 2020, mo de na yemamo. Some be you be a free way. Mo say a Supreme Court they interpret. So that time they man found Supreme Court for interpretation. ɛno deɛ mo de ba speaker wade na mo de silent ne ba speaker ho no man fan kɔma Supreme Court sɛ ɔmo interpret it and utie deɛ ɛkɔ so ne nsɛm ɛkɔ so a there's every clearest indication say the Supreme Court and I said the apex court is doing things in favor of the government. Several cases almost say the constituents will be deprived of representation. Hey, Natama Supreme Court and as a court they tabuno told Jesse question so say he shouldn't hold himself out as a member of parliament. I know the assign of for now they will be deprived of the representation. Koto de no budget. Meboa. Koto de no budget. A NDC MP there, and no dear, you should prevent his people from representation. But a MP before there, and no dear, they should give representation. Why? So for
in this case, there's an NDC member of parliament.
Please, but at the end of the day, it is government that is losing. What's the Rebecca say? The people of Sun Trophy.
So what you sought to do this for government to lose?
The point is that the Supreme Court's reason is that the people will be deprived of representation. Is that not it? Now, just question for send off for the omo here representation. Tama yi omo MP fi ho no. Omo de no mo here representation. Omo de no mo here o kama for parliament wo.
Did I suma me kakra
na ya mame ende Santrophy akpafo likpe ni lolobi for South for ye deprive you of representation for 4 years from 2020 till now. Omo de omo nye nipa omo de na moja na for mo. Omo de omo here representation, but they have been deprived of representation. So what is the Supreme Court talking about? Look, I am encouraging Abambagben to assert his authority.
He should defy the court.
Me say, I am encouraging him to assert.
He should defy what the apex court is saying.
Me say, Abambagben or your constitutionally set up body.
But the constitution is
the
highest
of government.
The constitution is the highest
of it. Why? Abambagben has not breached
the constitution is not even above the president.
Abambagben has
talk of a speaker.
Abambagben has not breached any constitution. Or say the constitution is clear, Article 97G and 8. Or say any member of parliament or cross the carpet, whether independent to a political party, whether a political party to independent, he
the
vacates his
constitution also states a high court and a bit to be declared will be seat vacant.
Inti Adena Supreme.
Yes, man. Yeah, first that case for my judgment and tackling. We did quick one. Now, I was since we born when you a hobby ever no court na judgment dental for one year examination consultation service in farm. Teeth replacement in farm. No matter so I teeth extraction. Scaling and polishing, no matter your root canal treatment at the amount. Mr. Nyopibia no be at the amount. Ombesha was in the gold, any silver, any crown be out pibiano. Ombe at the amount. Ombe choose no man fita. It's from more 0559 139 582 0559 139 582 and 0598 40 5674 0598 40 5674. Kumasa mo report junction. A war behind the total filling station. Saso na Techiman. Omo the Techiman market. Accra omo Nungwa omo saso atomic down. Kufodi omo adjacent the central police station at Echo Jomu Honomono. And attack rade omo pipe no off Tadisco junction. GN Bank premises one mo pe eho ena omo. Until we no na Friwa beto the biggest jackpot ever hit in the month of November. Who will be the luckiest? Star 712 hash. Star 712 hash. Na Friwa follow prompt no obeto ama ho. Na amount to be able to be no community be able join be no. Utie ye ni the mega jackpot no in November. Na uwini a. Obi owo community no mu bia no enye se scan ni bia di. Nti me sro to susu ni go on mo. Star 712 hash. Follow prompt no na osusu nyame ya dom na se bo November na osu atumi enya bia di na fe bibia so atumi akoye udi wie a na wanye sika kwa koto TV uto TV no ya no ape usupo na se want na ye bibia wie na dia to no TV every day bia ye offers of a nation ye telenovela kama pa obenya amnesty ene if you go better honum na fe chat room no or diagnosis some no actually some pa. There's an aspect of love, there's an aspect of suspense, danger, drama, and what have you. ɛwɔ Orphans of a Nation every day bia 4:30 but mo dia so benya Onua TV ahwe na afei mo tumi aboa na wotumi ate nneɛma bi ase ɛwɔ abrabɔ mu ya mawie
right Sam Okujeto senior former President Ghana Bar Association the Abetudra said he believes Peace Council should intervene in this issue. Gabi Asoro Chidako has come out to say, look, he believes the two parties should sit and deliberate on this issue before tomorrow. Vice President of the Republic. Osemonko post 7 December Kope majority. And you say near the panel. 1 minute.
Oh, as for Vice President, I don't respond to him. He's tired. Campaign now in so. And we are an opportunity to him to divert his attention from the difficulties he's experiencing in his campaign. And we will not engage him. Personally, I don't think I'll respond.
You
to
seek to abolish e-levy and betting tax.
Mm-hmm.
Would it stand the test of time? Because it has days.
Mm-hmm.
Is it just way of mischief?
We
and
will
you are just
initiate
because when you initiate it, it will take somebody to assent to it.
We will initiate.
It needs some days, and the processes won't take
the
just
NDC,
few
the NDC,
weeks that you are going back to Parliament.
The NDC is fully committed. And ne yetie Ghana for sufre. Baby abefa bia Ghana mabuno any nye 10% betting tax. Ghana mabuno any G11. All the draconian taxes.
But Munim says Sam Rano, if you initiate it and Nekura go see.
I am telling you that we will start processes, and when we win the elections, we will complete it. I know the MPP will put in place every measure to halt it, but the NDC is fully committed. Look, abain bia ni wo men yes kasina abain bia. These taxes, a pin in a bottle. Entimi for when you share. Obi a no wanya nantwi a wantimi afa nyankwan. Oma no kusi a ontimi fa nyankwan.
That's it. Nidi the Dr. Sammy Ayeh, NDC communication team member. In fact, Okasama Mebuno. Earlier on, Ote lawyer Kwasi Kwarteng Ono Kasama NPP was signed Ekasa Emma Ministry of Education. And I have for dance on the meeting.
Onua 95.1 FM. 95.1 FM. Yeah,